Rojas.
Yes, sir.
Okay, you said your client is gonna be getting on Zoom?
Yeah, he doesn't have the app. I just gave him the phone number. He's going to call in and do it by phone.
Oh, okay.
I get it's going to be on Zoom, but he's not going to be on camera because he doesn't have the app. He doesn't know how to do it. I just figured this is the quickest
Now
way.
let me say he gonna call in the court or he's gonna call
No,
into
he's
your
going to call
office.
in on Zoom. He should be calling in Zoom pretty soon. I think you can do a phone call through Zoom is my understanding,
Okay.
and he'll just be on audio.
No, we don't have to see him. I mean,
Yeah, he he just
I
doesn't.
don't know if somebody ever did that, but
He says he doesn't know how to do the Zoom part of it. So I figured the
If it
quickest
works,
way was just go ahead and give him the number.
okay.
With the phone number? Yeah. And I fixed his thing. It's just, I wanna try it.
it works. Yeah,
It does?
I've seen people do it.
I'll try. I had to do it before.
You can try it if you want. Well,
But you
let
have
me
to
do
have
this
the- you have
here.
to
Esta, se comunica con el juez. Tres personas más, el abogado de él y no hablé mucho.
Señor Rivera,
Buenos días.
aquí, ahí está el juez, nomás espera un momento, ¿ok?
Sí, ok.
Okay, Mr. Rojas. Okay, this is Jose Alberto Rivera.
That's correct, Your Honor.
And now Mr. Rivera, well, Ms. Rojas, your secretary or either you call the court to inform the court that Mr. Rivera did not appear because he was told not to appear. Is that correct? Is that
Yes,
correct?
sir. When I was in court this morning, I was reading my notes in the file. There were no notes indicating that Mr. Rivera had apparently talked to my secretary, and he had asked us to get the case reset. And I didn't see that. I knew there before that there was a couple of months that we didn't have any contact with him, and apparently he contacted us last week, and I didn't know about it. Those notes didn't get put into the file. So he had reached out to us apparently, and he did want to reset, and so I'm asking the court to recall that forfeiture from this morning and give us a new announcement docket, a new announcement date.
Now, state, do you have any opposition to recalling the bond forfeiture? It's stating that it was a mistake made on the part of Mr. Rojas' secretary.
No, none at all.
Okay, okay, Mr. Rojas, the bond forfeiture will be recalled. Hold on a minute. We need to. Mr. Rojas, this case will be reset until April 22nd of 2026.
Okay, thank
April
you.
22nd, 2026 at 9 a.m. And you could tell your client that he needs to stay in contact with you and the bondsman for his court date, April 22nd, 2026 at 9 a.m.
Okay, yes, sir. Señor Rivera, tiene corte el 22 de abril. Manténgase en contacto conmigo y también con el bond, ¿ok?
Ok, está bien, gracias, weón.
Okay. Thank you,
Okay.
Judge.
Gracias, ok.
Okay,
Gracias, juez.
you're free to go and y'all have a
Gracias, juez.
blessed day.
Thank you. You too,
Thank you,
Judge.
Judge.
Okay,
Thank you.
you're welcome.
All right. Okay.
Hmm. Hey, you may be seated. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 24 CCC Aura 2277. Case is styled the state of Texas versus Kenya M. Coleman. Let the record reflect that Ms. Coleman is present in court with her attorney Wright Kimberler. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Cornelius Williams and Attorney Farrell Nixon.
Good afternoon, Your Honor. Good afternoon, Bruce.
Let the record also reflect that the jury is now present and seated in the courtroom. And on yesterday, we had a conference, a charge conference, which was finished on yesterday. Is that correct, State?
That is correct, Your Honor.
And having reviewed the charge, you have any objections or any additions that you'd like to make?
No additions, deletions, or modifications. The charges are acceptable to the state.
And defense?
It's acceptable, Your Honor. No objection.
Okay. Members of the jury, I will now read to you the court's charge. The defendant, Kenya Coleman, stands charged by information with the offense of assault alleged to have been committed in Jefferson County, Texas, on or about the 3rd day of August of 2024. To this charge, the defendant has entered a plea of not guilty. I now give you the law that applies to this case. Our law provides that a person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. So that you may better understand the nature of the offense with which the defendant is charged, I now define certain terms and words. The term bodily injury means physical pain, illness, or any impairment of physical condition. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that the conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that a disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant Kenya M. Coleman did in Jefferson County, Texas, on or about the 3rd day of August 2024, did then and there intentionally, knowingly, or recklessly cause bodily injury to Diamond Davis, hereafter styled the complainant, by punching her about the face, you will find the defendant guilty, unless you so find beyond a reasonable doubt, or if you have reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his or her presence. If any question develops during your deliberations, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. You are the exclusive judges of the facts proven. the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a full person, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your full person to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last page is the verdict page. There are two sections. You have a top and it says or, and then we have a bottom section. Top section states, we the jury find the defendant not guilty as charged in the information with assault causing bodily injury. If that is your verdict, then your foreperson will sign on the top line where it says foreperson. Or we, the jury, find the defendant guilty as charged in the information with assault causing bodily injury. If that is your verdict, then your foreperson will sign on the bottom line. Does everyone understand? Okay? You have another one for me? Yeah. Don't worry. Okay, at this time, State, are you ready to proceed?
State's ready, Your
And defense, are you ready to proceed?
Ready.
Okay, Mr. Williams, the state has the right to open and close. You like to proceed?
May it please the court.
Yes, you may.
Violence has no place within our community and within our society. The reason why we are here, and I submit before you all now, that the state has proven each and every element beyond a reasonable doubt, that on or about August 3rd of 2024, at 8240 Willow Bend Creek, here in Beaumont, Texas, that the defendant, who's been duly identified here in court, charged into a home there, apartment B, and violently attacked the complainant in this case while her children were present. The injury which is caused is clearly shown within the state's exhibit. Now you have heard all the evidence within this case. Evidence came from the stand. You alone, as the judges just described for you all, are the sole judges of the facts within this case. You have all the facts before you. When we began this journey, you all made a promise to listen and evaluate the evidence presented, which came from the stand and exhibits. Through the filter of your own common experiences, we know that you will apply the facts to the laws in this case as given to you by the court, and for that, the state is very grateful. Counsel will have an opportunity, able counsel for the defense, to come before you and present an argument, and I'll present to you, I submit to you all, that argument will be one of subtraction. What I mean by one of subtraction, what the state did not do, what the state did not present. But I submit to you that what you do have, you have the phone calls, the 911 calls that happen in real time. You have the testimony of the neighbors who were there, the Bushers. The Bushers testified to what they heard. Miss Busher took the stand and she testified that she heard a loud bang. She called 911. You have that. That is state's exhibit number 1. That, ladies and gentlemen, is corroboration. You also heard from Miss Busher that she had seen a person before enter with a baby. But if you remember, she said that she saw that person enter what? Through the garage area. You've heard the testimony. You will hear. And it is the state's position and belief that you will definitely hear counsel during this presentation present things, and the state will submit to you all. You've heard the ability of both witnesses, but the defense will get before you, and during that argument of distraction, I believe will say to you all, where's the injury? How did the injury occur? Throughout his entire argument, all that the state will ask of you is to continue to ask yourself one question. Does that make sense? I submit to you when I stand up after counsel presents his argument and what we call rebuttal, it will not make sense. With that, we look forward to completing the entire arguments before y'all. But at this point, the state humbly submits that you have all that you already need to find the defendant guilty beyond a reasonable doubt.
Mr. Schindler,
How much time do we have?
15 minutes? Is that enough?
Oh, what the time?
Yeah, time there.
Yeah, can I have the screen blacked out from the argument?
Uh,
State has a burden of proof in this case that allows them to split their argument when we're making the parties being asked. And the defense is saying in the situation. So this would allow them to hear from me that you will have another opportunity to hear from Mr. Williams in the state. I always start on closing arguments, by referencing the court's charge to the last part where it's structured, well, you're duty to see that the case. I think it's important to realize that that is an individual responsibility that each juror has to see that justice is done. What I mean by that is that there's some sort of collective responsibility imposed on the jury to return a verdict. There are 4 references, after the attorney again, this decision. But you're not required to return again. In fact, you're not required to return the decision at all. You simply have an individual responsibility to see that justice is done. So what I mean by that is you have the duty to go back to the jury room and engage in good faith deliberations with your fellow jurors. And after good faith deliberations, if you can't come to an agreement, whether a unanimous agreement whether it's guilty or not guilty, it's not a failure of your obligation to see that justice is done. It just simply means that you can't agree. There would only be a failure on your part to see that justice is done if one or be able to surrender what you think is your reasoned vote, whether it's guilty or not guilty. You give that up simply to return a verdict, because that would violate what's your conscience and your reason to determine the correct result. And the idea is just to return a verdict. You're not required to return a verdict. If you can't agree, and deliberations, no further deliberations are seeming to be productive, then you can send a note out to the bailiff, through the bailiff, to report another crime that you can't agree, and then we can take it from there. So, and there are many times up here that juries can't agree, so it's like some kind of great failure, so. You'll notice, and again, what's not in the charge, the definition of proof beyond a reasonable doubt, it's not defined in here. The judge tell you not proof beyond all possible doubt. It's not knowing beyond a reasonable doubt, it's belief beyond a reasonable doubt. There are very few things that you actually know beyond a reasonable doubt. I'll submit to your everyday life. I mean, I know one day I'm gonna die, I am certain of that, but certain knowledge, right? But I don't know what happened out on October 3rd of 2024. It will have been apartment, wherever this was. I don't know. Mr. Williams doesn't know. You don't know. We weren't there. We don't know. The standard is belief beyond a reasonable doubt. And certainly, as I talked to you a little bit in the opening statement to you, because the defendant testified, it doesn't change that burden. It's not who you believe more in this case. It's not go back there and discuss, well, do we believe Ms. Davis more than we believe Ms. Coleman, or we believe Ms. Coleman more than we believe Ms. Davis, and that's how we're gonna decide the case. Ms. Coleman testified, and it's really to give her side of the story, and it's to allow you more evidence to evaluate whether the state's met their burden of proof. Some of the things that you can look at, obviously, all the evidence before you can look at all of the pictures, you can listen to the 911 calls, and determine, when making that evaluation, was there enough there to say that Ms. Coleman assaulted Ms. Davis and should be convicted and punished? I would suggest to you that there is reason for that. And after you look at the evidence that's been submitted, you will see that there are things that are questionable. I would start out, first of all, listening to the 911 call. Listen to the 911 call that Ms. Davis gives. She appears to be, and this is again my reading, she appears to be giving her contemporaneous account of what is occurring. She's attacking me, she's assaulting me. As if it's occurring in time at the moment. Does she say she's hitting me? Does she say she's biting me? Does she say does she give details? No, it's just, she's assaulting, she's attacking. But shortly after that, she shifts over and says she's harassing. Now, why would somebody, if they're in the midst of being assaulted, giving a contemporaneous account of being assaulted, why would she shift to saying she's harassing? Does that make any sense? Or does that seem to be more in alignment with what Ms. Coleman told you, that when Ms. Davis is making that call, then she's running down the car, and she's on the phone with the police on the 911 call, but she's not really being assaulted in real time when she's on that 911 call. She's getting her account down through the 911 call, or she's being assaulted, and getting it on record. Well, why would she shift and say she's harassing in the midst of being assaulted? That doesn't make sense. Now, I don't know, maybe it makes sense to you, but it seems like she said she would say something along the lines, well, she bit me and she hit me. She would give an account of what she testified. And again, you can compare the 911 call with, actually, this is a defense exhibit, her statement. See how it lines up? And how her statement lines up with her testimony. That's defense one, actually, is the written statement of the complainant. If you were to believe Ms. Davis's account, she's laying in bed upstairs, her children are downstairs. And again, this is in the statement. As she's laying in bed upstairs, she hears a loud bang with the door being kicked in, ostensibly by Ms. Coleman, with her children downstairs. So what would a reasonable person do? If they're upstairs in bed, they hear the door being kicked in, your children are downstairs. Well, wouldn't you immediately get out of bed and go downstairs to see what's going on to protect your children? Well, according to Ms. Davis, she kicked the door in, ran up the stairs. So before Ms. Davis could get out of bed, Ms. Coleman kicked the door in, ran up the stairs, and began to attacking me while on the bed as I wrestled to stop Penny Coleman. This is in her statement. So in other words, she hears a loud crash downstairs, door being kicked in, her children are downstairs. She doesn't get up, try to see what's going on when she hears the crash. She lays in the bed until Penny Coleman ascends the stairs and begins to attack her. Okay, well, is that reasonable? Again, it's up to you. Does that seem to be a reasonable account of what occurred? If anything. And then, of course, you heard the rest of it. She's screaming and all this other thing. But eventually, you know, they did proceed outside. You got the testimony from the Bushlers, which really, I would say, doesn't really establish that there was any type of fight, physical fight between the two, physical contact. And then you got these various pictures. I had the one taken down, Commissioner Williams will put it in just closing, of the injury, alleged injury to, Ms. Davis's eye. Let me just cover the height while we're at it. And she alleges she was bitten too, and there's a state's exhibit here that's supposed to show the height mark. And I'll leave it up to you, ladies and gentlemen, if you can look at the exhibit, I think it's. Actually, it's defensive, it's the defensive exhibit too. Of her arm where she supposedly bitten. I'll leave it to you if that's, you know, if that indicates a lifelike or not. But then you have the injury, alleged injury to her eye, that the state's introduced and had up there. Perhaps there's some discoloration, some indication of some type of injury, but if the events have transpired the way Ms. Davis related, there's a full-fledged confrontation because of the fight between Ms. Coleman and her. And you're talking about these two women going at it, fighting. I would submit to you that Ms. Coleman, you know, probably would have been able to do a lot more damage to Ms. Davis than what the state's indicated to do. If that was a full-fledged fight between the two of them, if you put the two of them up side by side against each other and just had them go at it, like the state was trying to tell you that occurred, but Ms. Davis probably would have been gotten a lot worse end of what she did, and what the state's able to show. She would have many more injuries than what appeared from this one exhibit between those two. The evidence that you have, I would suggest you, even though the defense doesn't have a burden, is more consistent with Ms. Coleman's version of what occurred. And what she told you was, that obviously Kelvin King has seen multiple women. Ms. Coleman has at the time had a 10-month-old child with him. Child was at the residence. Ms. Coleman went to retrieve the child. And of course, Mr. King hasn't shown up to court, but he was there. And Ms. Davis didn't like that. And it proceeded as it proceeded. There was a verbal confrontation between the two of them. Ms. Davis was enraged, angered, and chased Ms. Coleman around the car, as Ms. Coleman indicated. Made the 911 call while she was doing that, saying that she was assaulted, to get Ms. Coleman in trouble. And that's where we are today. Essentially, you have two versions of the events. And again, it's not on the defense to try to prove to you what happened. But the state has burden to present to you beyond a reasonable doubt. Their version is what occurred to punish Ms. Coleman, the locker room. And there's at least reasonable doubt between these two versions of what occurred, and that's what you're required to have to eliminate before you can convict. I would suggest that the version seems to be more consistent with what Ms. Coleman testified to, but you don't have to believe Ms. Coleman found him guilty. You just have to believe that is the version. I don't know how the discoloration or swelling or occurred. There was some indication that it may have been from Mr. King. We probably will get into that and some other stuff. I don't know. But if Ms. Coleman really was as enraged or as angered as Ms. Davis testified to, I think there would have been a lot more damage done than Ms. Davis by Ms. Coleman. But again, that's my opinion. That's subjective interpretation of things. But the two, if you line those two up and put them in the fight, what would occur? One thing that you don't have, and again, Mr. Williams is right about this, I'll let you find that on failures in the states, evidence or proof of the trial. I mean, the police responded to this. I mean, we know that on the report, right, the written statement of Ms. Davis that there's an officer down here at the bottom. We know that there's some police involvement in this. You know, suppose they went out to the scene and did an investigation, maybe, and talked to some people. Wow. Why aren't there any police officers testifying? I mean, I suppose they had body cams on, right?
Objection, assuming facts not in evidence, Your Honor.
It's reasonable assertion for him.
He can,
Okay,
that is not been, Your Honor, he cannot present before the jury in order to confuse and obfuscate the facts of this case by presenting fact that were not elicited from that stand or reasonable emphasis that can
I'm
be
not
drawn
attempting to
therefrom.
confuse or obfuscate, Your Honor. I'm commenting on the lack of evidence.
ladies and gentlemen, questions and comments of the attorney do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. You may proceed.
Yes. I think it's fair to infer that there was some police involvement because there's an officers indicated down here at the bottom. I don't know if any officers responded. I don't know. Maybe they did, maybe they didn't. If they did, then maybe there was body cam. I don't know. I don't know. But you don't have that. And body cam evidence would be able to record the demeanor of a person at the time of the events.
Judge, able counsel for defense knows that that argument is improper.
Not improper.
He cannot present evidence before this jury which was not elicited.
You comment on the lack of evidence, Your Honor. That's reasonable.
Okay,
I don't understand what the state's objection is.
okay, then Mr. Himmler, you may continue.
And again, Mr. Williams can address this in his closing argument too, if he has an explanation. Just saying that obviously there had to be some type of police involvement in this case, or it could be referred over to the district attorney's office, and you haven't heard from any anybody involved. Then you can consider that for whatever it's worth. I'll leave it at that. I don't know, that's really about all I have. I can't, this is the last time you're gonna hear from me. I just ask that you look at the evidence, go back and deliberate it, and I would suggest to you that there is reasonable doubt here, but it hasn't been proved beyond a reasonable doubt, and you should find this cause not guilty. Thank you.
Okay. Mr. Williams, you have 11 minutes, 40 seconds
Thank you.
left.
Ladies and gentlemen, you do know what happened. How do you know what happened? Because you were brought there from the evidence that came right from here in the testimony. You were brought here by Diamond Davis. You were brought right here in this courtroom that accounted for what happened at 8240 Willow Bend. Now, when the people sat in this chair and gave the testimony, it was up to you all to judge the credibility of the stand. When Diamond talked about Demi, Major, and Zoe, you saw her demeanor, you saw her testimony, you saw how she, as a mother of when those children was present, how she began to choke up. You saw her emotional state. You saw when she looked at her own photograph, what had happened to her. You remember the evidence while she was upstairs. I submit to you that it doesn't take long to kick in the door, run up the stairs, go straight past those kids and attack her. Remember when she testified that her eyeglass arm was sitting there on the bed? The PlayStation was busted. It's up to you to judge the credibility of the witnesses and what makes sense. It's true, I wasn't there. Able counsel for defense wasn't there, but you know who was there? The Bushes was there. From what they heard, we know that Diamond was there. We also know from the testimony that who? Kelvin King, he wasn't there. How do we know he wasn't there? Because he had left to go get food or something. The door would not have been busted had, one, the defendant had what, a key? Two, had Kelvin King let him in. That did not happen. Council points out. We don't know how those injuries occurred. I submit to you that you do know how those injuries occurred. Because you heard it from the stand. And I submit to you, I place before you that rapid talk filled with untruths as spewed by this defendant, that is not reasonable doubt. That is a concoction of a story to obfuscate the truth. Now, does that make sense? I submit to you that that does not make sense. And what has been shown beyond a reasonable doubt is that Diamond Davis was attacked that day by none other than Kenya Coleman. Therefore, we ask, will you go back there, still applying that filter that everyone follows, and we know that you guys did and will. Just check the box with the foreperson that find this defendant guilty for what she did. There is no place in our community for wanted violence. No place. Find her.
Ladies and gentlemen of the jury, all the evidence, the court's charge, the closing arguments of counsel are before you. I'm going to hand the bailiff the court's charge, but before I do that, I need to inform you that one of you, well, you are an alternate, and therefore the alternate cannot go into the jury room with the other six. The person who is the alternate is Andrea Marie Bover. What is that? Ms. Bover? Okay. So Ms. Bover, should something happen in the deliberation, you'll be allowed to complete the deliberation if something happens to one of the jurors. So at that time, as the juror goes into the jury room, you can either sit here in the courtroom, or if you want to sit in the hallway, you can do that. So at this time, Ms. Bailiff, I'm handing you the charge. Okay. Everyone, please stand as the jury exit the courtroom into the jury room, and we'll stand in recess until we receive a verdict. Go to be in recess. Oh, wait, it is.
Because, if you.
My thing just went off. It's still on.
Yeah, it's fun. They'll show that photo.
Next meeting.